Good afternoon, everybody. This is Attorney Marjorie Brunelli, and today I'm going to address the issue of parental responsibility and custody in Florida. I think what a lot of people do not know is that joint custody in Florida is referred to as shared parental responsibility. So I think there's a lot of confusion in that sense because a lot of people that come from another country, they're used to the term custody and they get a little bit confused when you say you're going to have shared parental responsibility. And then the question is, well, how can I get full custody of my minor children because I don't want my minor children having contact with the other parent? So in Florida, the standard, the presumption, I guess we can say, is that what is in the best interest of the child or the children is shared parental responsibility. So the child can have contact with both parents and that way develop, intellectually, emotionally, psychologically, socially, in the best way possible to grow up into a healthy adult. So obviously, that's what the presumption is, that both parents are fit to care for that child and both will provide what the child needs, child or children, need in order to grow up to be a good member of society. Let's put it that way. So the presumption is shared parental responsibility or joint custody, if that's the term you use to. So in what situations, because a lot of people ask that, in which situations does the court allow for just sole custody or, not joint, not shared parental responsibility? So there are a few factors that the court's gonna look at in order to determine that type of situation. Of course, that those situations are not common in a sense if you're comparing to shared parental responsibility, because that's really the goal, is for both parents to have full parental rights and responsibilities as to their child or children, and both parents to make all decisions, the most important major decisions that affect the child's lives together. So any decisions involving education, health care, and so forth and so on, they are supposed to be made by both parents. Sit down, have a conversation, and determine what's best for the child. Obviously, that's easier said than done, particularly in cases where the parties are getting divorced. But that is the goal. It's for both parents to be completely involved in the children's lives and have, time sharing with the children. Sometimes, obviously, that's a separate issue. I'm not going to discuss time sharing, but depending on the parent's schedule, sometimes one parent spends more time with the child than the other, and then they can always make up for it during vacation and time off from school and work. But that's a subject for another video. So going back to the factors that the court's going to look at in order to determine if revoking a parent's right to custody or share parental responsibility is something to be considered. So obviously, if that parent is abusing the minor child, that's one huge factor that the court's going to look at. And there are different forms of abuse. Obviously, there's physical abuse, sexual abuse, verbal and mental abuse. So I'm not going to go into the details. If you need to discuss your particular case and if you want to address and see if maybe that would be your situation, you can always contact me. All my information is up in the bio. The phone number here is 954-474-7703. But each case is different, so it's much better if you sit down with an attorney and discuss the issues in your particular case, and that way you have a better understanding if that is your situation or not. But going back to the factors, also neglect. So if maybe the parent is not hitting the child or abusing the child physically or in some other way, but the parent is neglecting the child and it's not providing, for example, for a safe environment for the child, is not providing food or education, access to school, access to health care. So there are different things that need to be discussed as to what exactly is considered neglect. So again, it's, on a case-by-case basis, but that is another factor that the court is also going to look at in determining if revoking that parent's rights to the child is something that is called for. And other aspects that are also going to be taken into consideration is if that parent uses, I should say abuse, alcohol and drugs. So obviously if the parent is an alcoholic or a drug addict, that's definitely going to come into question, because if the person cannot take care of herself or himself, how they can take care of a minor child. So that's definitely something that the courts are going to consider as well. And lastly, the other thing that also comes into consideration is if the parent has any serious mental issues, mental illness. So obviously that's going to take a determination by a doctor. It's not simply, my husband is a narcissist or my wife is crazy and she's a narcissist and I don't want my children with him or her. It doesn't work like that. So you really need to have a therapist involved, psychiatrist involved, the psychologist involved, and the person needs to be diagnosed with a serious mental illness where that person can pose a threat to herself, himself, or the child. And there's, treatment involved. Sometimes the person needs to be admitted to a mental facility. So there are different levels and different situations that we would really need to discuss, on a case-by-case basis in order to determine and see if maybe that would be a situation that would be happening in your particular case. So those are the factors that the court would look at in determining if shared parental responsibility is not in the best interest of the child. Now, there are certain circumstances, and I'm not going to go into much details because I want to do another video about this, but there are certain situations, for example, that the circumstances are not as extreme, but they do pose a certain risk for the minor children. So in those particular cases, other options would be supervised visitation as well as a step-up parenting plan. And what that means is, for example, just to make it easier to understand, let's suppose the person has anger issues. So obviously that person is going to have to attend anger management. So the way it works is, as the person goes through the anger management therapy or process, or however it's referred to, or other kind of issues where the person needs to go to therapy, as the person progresses in that treatment, he gets to spend more time with the children, probably in a supervised setting. But as the person goes through the process and the programs and the therapy and treatment, he'll be able to spend more time with the children. That's why it's called a step-up parenting plan. And the goal really is to get to the point where both parents can spend a similar amount of time with the children. So that's a separate situation, it's different. I really wanted to do the video just to address the more serious issues where a court can decide or determine that one of the parents is unfit to have contact with the child, the minor children or child, and address this question, because I get asked this question a lot more often than I think would be, I guess, a good thing. So anyways, that's it. I just wanted to do this video to clarify this issue because it is asked quite a bit, and I hope it helped. So if you have any questions, you can always reach out and talk to me. And that's it for this video. I'll see you in the next one. Have a great one.